You may have heard of a recent decision of the Supreme Court of Canada, which has made major changes to the law of contracts. The case is called Basson and Renew, and it will have significant implications for all contracts in Canada, including employment agreements. HR professionals in Canada need to understand its basic requirements. In the Basson decision, the Supreme Court of Canada created a new duty on the parties to a contract. The court named it the duty of honest contractual performance. This new duty can be simplified in a few principles. Number 1. While Canadian law has long held that parties to an employment contract must act in good faith, the duty of honest contractual performance imposes a specific requirement. Parties to a contract cannot lie to each other or otherwise knowingly mislead each other about matters directly linked to the contract. Number 2. The duty of honest contractual performance is a duty imposed by courts of law on all contracts in Canada. It means that in the case of employment agreements, there is a simple requirement not to lie or mislead the other party during the course of the contract itself. Number 3. Parties to an employment agreement cannot avoid the duty to perform the contract honestly by including language in the agreement that says the duty of honest contractual performance simply does not apply. However, in certain circumstances, which have yet to be determined by the courts, the contracting party may be able to relax the requirements of honest performance, so long as any relaxation of the duty is made in express and specific language in the contract. You can see that the court's decision in Basson will have a major effect on the way employers and employees act with one another over the course of the employment relationship. While the duty of honest contractual performance may well be a simple requirement not to lie or mislead the other parties to a contract, the case raises many complex issues.